Hi, everyone. Thank you so much for dialing in to our webinar today. I would like to get started, and I will pass it on to Todd Ruback, who's our Chief Privacy Officer and VP of Legal Affairs at Evidon. Todd, the floor is yours.
Thank you, Pi. Before I jump in, let me just do one last audio check. Can you hear me okay?
Yep, I hear you loud and clear.
Wonderful. Thank you. And hello, and thank you all for joining us today for this important webinar, ePrivacy and GDPR Game Changers. Are you ready? It is hosted by Evidon, and as Pi, my colleague, said, my name is Todd Ruback, and I'm the Chief Privacy Officer and VP of Legal Affairs here at the company. I also want to thank our panelists, Vivienne Artz, who is the Managing Director, Head of International Privacy for IT and O&T at Citi, and John Bowman, Senior Principal of Promontory Financial Group, an IBM company. They both are online and calling in from London, and where it is late afternoon there. So thank you both for agreeing to be part of this panel. The purpose of this webinar is to continue the conversation that Citi began in its report, the Citi GPS report entitled How Regulation Could Alter the Path of Innovation. During this webinar, I'll serve as the conversation facilitator, and we'll glean insight from both Vivienne and John on how both the proposed revisions to the ePrivacy regulation, what ultimately will be the regulation, and the GDPR, both significant EU data protection regulations, will impact data and innovation for companies. The basis of this conversation is, of course, Citi's GPS report, which Vivienne and John were both interviewed for. If you haven't already read this report, I encourage you all to do so. We'll provide you with a link to it in a follow-up email, along with the recording of this webinar. If you want to ask any questions, please enter them in the questions panel in the GoToMeeting tool that you have on your computer, and it'll come to me directly. So the Citi GPS report, I think, is unique in that it is both broadly comprehensive about the ePrivacy reg and the GDPR and their impact to data and innovation, as well as vertically deep and specific. At its highest level, though, in my opinion, the report identifies the challenges that these data privacy regulations may pose to many of our organizations and may force and how they may force us to all rethink not only compliance, but at the same time our approaches to data and ultimately product and services innovation. So, you know, it's a really unique perspective and worthy of our consideration and thought. With that, let me just, with that preamble said, excuse me, I just want to begin with a brief overview for those of you who may not know Evidon. I'd like just to take a minute and tell you who we are and what we do. So Evidon is a global technology company that makes really great software solutions for companies to comply with complex privacy and data protection laws, such as the ePrivacy directive and what will be the regulation. We have a unique viewpoint in that we sit at the intersection of both ePrivacy and the GDPR as we build our compliance tools. But because of that perspective, you know, we've become really good at two things: monitoring and transparency and consent. Well, we deliver a comprehensive patented solution to find the areas of that companies are concerned about on their digital properties, on their websites and apps that are used for performance, security, data leakage, and most importantly, in my opinion, of course, privacy compliance. And we're able to see all the invisible activity across a company's entire digital marketing supply chain. Additionally, that's wonderful, but the ultimate question is, what do companies do with this digital intelligence? Well, they use our tools to be transparent about their data practices and, where appropriate, to get consumer consent. Critically important, both of these concepts under the GDPR and the ePrivacy reg. And now my computer locked up. Oh, there we go. So before we jump into the report, and in order to make the Citi GPS report contextually relevant, I just want to take one more minute and do a quick overview of both the proposed ePrivacy reg and the GDPR. I'm not going to belabor the details, but because so many of the folks know the details already, but just by way of review, the ePrivacy directive is presently being revised and is being fast-tracked into into regulation. Hopefully, it's an ambitious time frame, but the proponents of the ePrivacy reg are hoping for the regulation to become effective at the same time as the GDPR, 25 May 2018. And it's important to remember the aim of the ePrivacy regulation. It aims to protect privacy and confidentiality of electronic communications. But it's important because, because of that aim, that is why conceptually it won't become part of the GDPR, but will live in parallel to it. But critically, if the proposed changes to the ePrivacy regulation come into being, they will adopt GDPR penalties and also the GDPR notion of consent. And the GDPR, as I mentioned, will become effective May 25, 2018. And its purpose is really at the highest level to give power back to the people, control over personal data, back to the individual through a series of new rights and obligations. But it's a massive piece of legislation, which I think there's certain sections of it are brilliant. But there are huge potential risks and downsides for non-compliance, including 2 tiers of penalties, the higher of which can ultimately be up to 4% of the company's global turnover, what we in the States call gross revenue, or 20 million euros. This will mean, at the end of the day, a top-to-bottom process review and change, something that is, we're going to talk about a little bit, and is a challenge for anyone. So, with all of that said, let's talk about the report itself and get the insights from our panelists. Before we dive into it, I just want to take a moment and say that we are really quite grateful to the authors of the Citi report for using this report as a platform to begin an important conversation to help companies, and I'm going to quote from the report itself, to help companies navigate the global economy's most demanding challenges, identify future themes and trends, and help our clients profit in a fast-changing and interconnected world. It's pretty profound and powerful, but really it sums it up, and I think that is where we're going to start. So I'd like to begin our conversation with the report's conclusions, which is also a good place to start with both Vivienne and John. Vivienne, I'm going to put you on the spot first, if you don't mind. We see that the GPS report's conclusions first will fundamentally alter the risk-reward of data use and will alter long-term opportunity. Can you explain that? I mean, intuitively, I think I get that, but in what way will the ePrivacy reg and the GDPR alter the risk rewards for data use, and how is it going to alter the way we perceive long-term opportunity?
Thank you, Todd. I'm delighted to be here today, and I was delighted to have the opportunity to participate in this report, which was put together by my colleagues. And it was very exciting to participate as well, because I've known John for many years, and John and I have been toiling away in the data protection space for a very, very long time. And it's really only in the last sort of 8 years or so that data protection has come to the fore. And actually seeing a report like this, which demonstrates the importance of data, particularly personal data, in today's world, shows that the topic has come to a level of maturity that it's never had before. So it's interesting, if you go back about 10 years, really there weren't that many data protection laws out there. The EU sort of led the way as the gold standard. But if you look about today, over 100 countries in the world have data protection laws either in draft or that have been passed. And so it's an absolute feature of the world in which we live. And the interesting thing about the GDPR is that it was very much driven or written with the new information society services in mind. I think it's going to have the biggest impact on them, but it is going to have huge impact on other established business areas like financial services. And I don't want to say that they are all unintended consequences. Many of them are intended consequences, but there are a significant number of unintended consequences when one sets about putting in place legislation that has huge horizontal impact. And that's the interesting thing about the GDPR, is that it is designed horizontally. It's not specific to any particular industry, but in its focus on information society services, in its focus on the internet, on its focus on that value transaction of the payment for the services is the provision of your data, they are looking to reset that dynamic altogether. And they are going to reset that dynamic through the GDPR. And I think that's where the biggest impact, the biggest intended impact is going to be felt, is with information society services, which have developed an entire business model worth billions and billions on that transaction of data for services. Other business models obviously work differently. Most businesses use personal data, but it's not core. It isn't the currency. It's not the oil from the ground in the way that it is for information society services. So I think for them, the reward is high, but the risk, of course, has increased. And whereas before we didn't see much power, much in terms of enforcement that really bit the bottom line, I think we're going to see that change dramatically with the GDPR in terms of fining. I don't know, John, if you want to talk about what the fining is under the GDPR, it's eye-watering and unprecedented.
Yes, so I think, thank you, Vivienne, and thank you, Todd. It's a pleasure to be on this webinar as well. And just to add, the report produced by Citi is just a very impressive piece of work, and I'd certainly recommend that all listeners here take a look at it. But in terms of the finding, the sanctions regime which are proposed in the regulation and in the GDPR and the proposed ePrivacy regulation are, as you mentioned, Todd, either 20%. 20 million euros or up to 4% of global annual turnover. So turnover means revenue. And so potentially that could be quite high for many companies, because it is the higher, if the turnover is higher than the maximum fine, then that's the one which applies. So potentially the 4% global turnover could be the one which applies. It is a significant uplift on what is currently in place under the various domestic regimes which derive from the 1995 Data Protection Directive. For example, here in the United Kingdom, the maximum fine at the moment is £500,000, but we can see that a global turnover fine could be many times the size of that. Where it came from, I think, to some extent, was the desire by the European Commission to reflect the fact that the protection of personal data is a fundamental right under the Charter of Fundamental Rights. Those of you who've been following the progress of the GDPR over the last 5 years will know that there was a very contentious dossier, to the extent that the negotiations themselves lasted 4.5 years. When it was going through the legislative process, in the European Parliament, a record 4,000 amendments were filed at that particular stage as well. So it could be said that it's the most lobbied file in EU history, and certainly it captured the imagination far beyond what we might consider to be the sort of natural outreach of this. But I think the rights element is important, because it does mean that companies need to focus on to what extent they are able to protect the personal data of the individual. We've seen some court cases in the European courts over the last 2 or 3 years, which have specifically referenced that Article 8 right, the right to the protection of personal data. For example, when the Data Retention Directive, which was around communications data, was repealed, and also when the Safe Harbor, EU-US Safe Harbor data transfer agreement was declared invalid as well. Those the court referred directly back to those rights. But the GDPR itself has a kind of dual purpose, which is one which all organizations need to consider. One is there to protect the personal data of individuals and protect those rights, as I mentioned, but the other is to facilitate the free flow of data. So there is a benefit, it is acknowledged that there is a value to be gained through the free flow of data. It stimulates the economy, it provides individuals with services which are innovative and useful, and provide services which are there to be enjoyed by individuals as well. And it's striking that balance between the protection and the free flow of data, which is key to sort of understanding GDPR and making and possibly gaining an opportunity from it.
Although it's interesting though, isn't it, that the free flow of data really is a free flow within the EU. So I think that's probably one of the, it's a tremendous opportunity within the EU, but the challenges are still there about enabling the free flow of data external to the EU, and reconciling that with innovation as well.
I think so, and I think to some extent, the adequacy, so-called adequacy process, where the European Union can effectively recognise countries outside the European Union as providing sufficient safeguards to receive data concerning individuals in the EU. It's been a rather slow process up until now. It's been around since I think the early decisions came from the year 2000 onwards, and they cover a handful of territories, some large, some small. So larger ones, for example, like Canada and Argentina, and smaller ones like the UK Channel Islands, for example. But to some extent, the GDPR tries to set out a global framework, because effectively, if any organisation outside of the EU wants to process data in the EU, for example, they're providing information society services, then they have to be compliant, even if they do not necessarily have an established base within the physical territory of the EU.
So,
go ahead.
Yeah, no, look, guys, that I know we have hundreds of people listening in, and I don't want to get us off piste too far, but I can chat about these issues all day. But before we talk about the latter point that you mentioned, John, regarding the GDPR is meant to facilitate the free flow of data. One of the questions I get asked all the time, certainly by my US-based colleagues, is, yeah, there's a lot of risk of penalties and fines, but what's the actual risk? How do you quantify it? I mean, is the GDPR like Y2K in that it's a hard date where, with Y2K, there was, the risk of the lights not coming on, beginning, January 1st, 2000, or is this something that, as long as we're demonstrating good faith effort towards compliance, we'll be okay, and we don't really have to be fully compliant by 25 May 2018? I guess it's the lawyer in me, but I counsel my colleagues. I'm like, you don't want to be that guy. Don't be that company that isn't set to go. But what is the risk if companies aren't fully compliant?
Okay. There was a conference here in London a couple of weeks ago, and there was a senior official from the UK Information Commissioner's Office who was asked the question, is there a grace period for compliance in terms of companies after the 25th of May 2018? And effectively he said no grace period. The GDPR itself built in a 2-year preparation transition period, and I think it's important that companies and businesses make the most of that transition period to get as many of the processes and measures in place in order to start demonstrating compliance with the GDPR. And it's a key element of the GDPR is the reference to the accountability principle. So GDPR does provide for a risk-based approach. Companies aren't necessarily expected to do sort of they're not expected to take undue risks, but at the same time, the measures they do take need to be proportionate and necessary in terms of the risks which they are managing. So I think the important thing for businesses is to identify their priority areas. For example, do they process sensitive data, health data, for example? And does that need special protection? What's their current level of compliance with the existing legislation? GDPR is a major overhaul of the current framework, but at the same time, it's an evolution of it. And to some extent, the businesses that already have good practice, good governance arrangements, and good data management in place already under the existing regimes should find it more straightforward to transition to GDPR compliance rather than those who are starting from a low level of data protection maturity. But to sort of come back to your question, I think businesses need to have an honest assessment of their state of readiness at the moment, and the earlier they can do it, the better, I think.
Sure, no doubt about it. I'd like to segue over to the second report, second conclusion in the report, and in that the report also says or concludes that the 2 regulations will require a systemic process change and approach to data use. There's a lot in that, and John, can you help us unpack that and just walk us through what this means internally to the way companies are going to be doing business?
Yes, well, I think to some extent, it depends how the companies are applying the current principles under the directive and under other frameworks that are out there. And but I think the core principles remain the same in that all processing needs to be lawful, fair, and transparent. So, but at the same time, I think the consumer needs to be much more at the heart of the decisions which are made about the processing of their personal data, because their rights are enhanced under this. They have the ability to, request data in a portable format, or to ask the data be deleted, or to obtain a subject to file a subject access request free of charge, which is a significant change here in the UK at least. So, and I think there's growing awareness as well. So I think consumers are becoming more savvy around their privacy rights. Data breaches tend to make the news now, and we can see that some of them can have significant effects on businesses. I think there's more activism in this area, and that's something which certainly puts companies under spotlight a lot more, and to some extent exposes things for regulators. So, in terms of the process changes, I think the systemic process changes, absolutely, there might need to be some major review and overhaul of the systems which are already in place, not only in terms of the actual business processes and the policies which underpin them, but maybe the technology which delivers some of the requirements of the regulation as well, particularly when looking to address the enhanced data subject rights which individuals have. Vivienne?
I think an additional area that may be difficult for many organizations, financial services already has a sort of mature way of dealing with breach notification, but many other sectors don't. And putting in place a process in order to identify breaches and then to notify them to the relevant data protection authority and or customers as necessary, I think is going to be a systemic change that many organizations, particularly SMEs or non-financial services or non-regulated areas, because telcos do this already, are going to have to embrace. And that data may not necessarily be held in the EU, but if it relates to the EU, then we're going to have to notify it. So it becomes a global impact potentially for a business model.
I'd agree.
Thank you both for that. I mean, a process change is often so difficult and painful for organizations. So I know this is a big challenge. I'm trying to advance my slides, and there we go. So I'd like to move on to in the report what the experts are saying, and lucky enough, I've got both of you on the phone with me right now. So I love these quotes, and I have a feeling that you both have touched upon them already, but I'd love for you to flesh them out a little bit more. Vivienne, you said in the report that the GDPR has taken the issue of data protection and ePrivacy from somewhere in the bottom 20 of issues that corporates worry about and spend time on to somewhere in the top 10. Why is that? Is it because of the huge amount of the huge risk that companies are facing for not getting it right? But it sounds like to me what you are intimating is that this is now a senior level issue, if not board level issue.
Thanks very much. Yes, it has really shifted. I think it's a couple of things really. The penalties for failure to getting it right are unprecedented. So the fining power we talked about earlier, 20 million euros or 4% of global turnover, whichever is the larger. For a larger organization, you might want to work out what that 4% is. It could be in the billions for large globals, which is, an extraordinary amount. But it's a combination of things. The penalty for getting it wrong is incredibly high. But there is a huge enhanced awareness on the part of the public around data protection as well. So with social media, people are so much more aware of privacy, their privacy rights, the Internet of Things, the impact on them personally, in addition to the impact of data in the corporate sphere, so how corporates handle data. So we've had high-profile data breaches, that's raised awareness. People look at their own mobile phones and, if something goes wrong or if there's a change or if a particular app they use is now bought by a different company and they want to share all their data across, but actually they hadn't anticipated that their information would be shared in that way. There's a huge heightened awareness around data protection. And the only way to really get it right is, in my view, is to change the culture of an organization. So rather than seeing it as a tick box exercise, rather than seeing it as an evil with which one has to comply or a bureaucratic burden, is to actually change the culture in the organization so that you embrace data protection positively, that it can be embraced as this is how we work well with our clients, this is how we manage data in a positive way within our organization. This is something that's going to differentiate us from our competitors because we've gone the extra mile to be transparent, to give our customers options, and to understand how our data is flowing and to protect that data. So I think it's a combination of things that has pushed this into the top 10, not least of all the penalties for getting it wrong. But I think it is definitely, it's in the headlines whenever you open the paper. You'll see frequently in the week topics on personal data, on data issues, on data ownership, on data transfer, on data usage, on data rights. So it's absolutely up in the top 10 now.
And I want to come back to that. So you touched upon a really nuanced but important point. But before we loop back to that, I want to put John on the spot a bit as well. John, your colleague at Promontory, Simon McDougall, and you both said in the report, and I've got your quote up here on the slide, that the GDPR represents change for everyone, even if they have a good framework in place. If they don't have anything in place, then there's considerably more effort required. And I know you were touching upon this just a moment ago, but can you unpack that and talk about the framework and how companies can manage this change?
Yes, absolutely. And I think the first thing to say is when it represents change for everyone, I was previously working in government, working on GDPR and for the UK government. And one of the things we used to always say when trying to demonstrate how important this was internally within government circles was that this is a regulation of truly horizontal application. So there is barely a part of any organization which isn't touched by this. So everything from consumer-facing services to internal services such as HR in particular, but other things as well. Everyone needs to sort of understand how the GDPR and ePrivacy, when that comes along, affects them. And I think to some extent, maybe the existing regime has allowed some businesses to think, well, maximum fines aren't necessarily that high. This data protection or privacy is something which might take up 25% of someone's job in legal and compliance, and they'll deal with it when they need to, rather than taking a systematic approach to compliance. I think GDPR in particular is a game changer on this, because firstly it expands the territorial scope of the regulation, so it doesn't just apply for those businesses which have an establishment within the European Union. Its scope extends worldwide, where companies are processing the data of people who are in the European Union. Also, the definition of personal data as well is very much expanded. We can see that things like cookies and IP addresses come in within that definition as well. So effectively what that means for businesses is that they need to sort of understand what their data processing activities are. This is something which will need to be documented under the GDPR in particular. A record of processing activities needs to be maintained, which includes the purposes of processing, the legal base for processing, and who data, what data is transferred to our other organisations and in and outside of the EU as well. And the individuals, the data subjects, consumers, they will have more information about what the data processing is. So effectively, they'll be more empowered as well. So there might be much more coming in from the consumer point of view as well. We know that there's publicity going on from the regulators, and I think when GDPR does go live, and whether or not ePrivacy goes live at the same point remains to be seen, but there could be some considerable publicity around it at the time. Certainly, there was quite a bit of media coverage, albeit more specialised, around the negotiations as they were going through. So I think some organisations are, you know, the maturity of the controls in place and the sort of frameworks and the governance in place does vary from organisation to organisation. As Vivienne says, I think financial services organisations, banking and insurance in particular, are reasonably well prepared to the extent that they are used to operating in a highly regulated environment, and some of those regulations already touch on the management of data. Other sectors, I think, you know, they have started to grow the use of their data over the last 10, 15 years. We see, you know, mobile apps, you know, the use of loyalty cards in retail, for example, and various other innovations, and of course all the online services which we've become accustomed to over the last 5 years or so. Those kind of services may not necessarily think data protection first, and they might have further to go because they haven't got the sort of mature sort of risk management and governance models and processes and policies in place. So that could be considerably more effort. And I think, I mean, one of the interesting elements in the report is where it says that the larger, more well-established companies may be better placed to deal with the GDPR. Maybe it's the smaller, more innovative companies which need to think more about how they work towards compliance. And of course, the other element is that time is ticking. There is a deadline on this. We'll be approaching the 1 year to go anniversary very shortly, or milestone, I should say. And I think at that point, it may be a bit of a wake-up call. Businesses which have started down their road to implementation.
Yeah, and oh, I'm sorry. Go ahead, Vivienne.
No worries. I was just going to say, on a practical note, and it's up for debate, is the extent to which existing terms and conditions with your customers, which may be compliant under existing law, you know, is there the ability to transfer those over? Are they still valid, or do we have to update the terms and conditions with existing customers and update the terms and conditions with existing vendors in order to meet the enhanced requirements under GDPR? And that guidance is still pending, but when you read the difference between what's required between the directives and the GDPR, I think a massive repapering exercise needs to be anticipated by many, if not most, organizations. And
to add to that, it may well be a prerequisite, I should say, of businesses who, if you provide a service and you're looking to bid for a contract, for example, it may be that the companies, the potential clients will find that you have appropriate measures and can demonstrate GDPR compliance as part of a bidding process. Or so the issue may be forced in that direction rather than the company's own volition in terms of working towards implementation, because that might be much more of a requirement in terms of contractual negotiations as we go forward.
There are so many topics or questions I want to ask you both, and they're just piling up from the insight. But I want to circle back to something that you touched upon, Vivienne, a few minutes ago, and that is the culture aspect of the GDPR, which I think is nuanced. But one of the brilliant things about this massive bit of legislation is that it's going to require a huge cultural change internally for companies, and that's where I see this as being much more than a compliance exercise where you have to tick off the specific boxes. Instead, it's going to force companies to change the way they do business, not only from a process perspective, but also change the way they their relationship with their customers and consumers. And that's the transparency bit of the transparency obligation that's embedded into the GDPR, where organizations are actually legislatively required to have some sort of a consumer-centric conversation or way to have this bi-directional collaborative communication going to reach out and tell the consumers, these are your rights and here's what we do with your data and here's our data practice or our approach to data. What do you think? Can we use your data this way? And that's really difficult. I mean, the transparency bit, that's what Evidon has been thinking about long and hard. But actually doing that as a legislative obligation, to me, that's where the rubber meets the road. And that's where companies are going to really have to think through their data strategy and innovate.
And of course, Todd, one of the main sort of innovations of the GDPR is the requirement to designate a data protection officer. And there is, in terms of the position of the data protection officer, as well as providing advice on compliance and so on, is that they would act as a point of contact for data subjects in terms of any issues which they might have concerning their the processing of their personal data. So,
but John, I mean that the designated data protection officer, that's really to serve as the main point of contact between the company and the regulators. I'm talking about the transparency obligation to the consumers.
Absolutely, and the rules say that the data subjects may contact the data protection officer concerning their data processing activities as well. So there's an interesting angle on that, in that unlike an audit or an internal compliance function, they will have a direct line of communication with the data subjects as well, and data subjects will be entitled to contact the data protection officer to deal with to potentially address any issues which they might have.
Yeah, the double-facing aspect
Yes.
is quite hectic. Todd, in response to your two comments, first of all, I don't know whose dog was barking, but I love the dog barking because it's my.
I'm sorry, that's my dog. I'm working from home today. Sorry, guys.
No, but what I was going to say is I love the dog barking because it reminds me of my favorite cartoon in relation to the internet, which, if anyone can remember back, it's that cartoon of the Labrador on the computer, and it said at the bottom, when you're on the internet, nobody knows that you're a dog. And of course, that used to be true, but it just so isn't true today. And that's something that the ePrivacy regulation is really seeking to address, which is all about cookies and tracking and direct marketing and fingerprinting and all of those technologies that track you all over the place and that can identify you, and that needs to change. And interestingly, that links into the topic on culture. So it does require culture change within the organization to embrace the principles of privacy. But one of the things I've always observed about data protection is that there are different cultural approaches to privacy. So the cultural approach to privacy in North America is very different to the one in Asia, very different to the one within Europe. And although it is the European Union, and this is a single piece of horizontal legislation that goes across the 28 member states, there is a difference in cultural approach even within those member states of the GDPR. So the data protection officer concept culturally is very, very normal within Germany. They've had data protection office for years. This is a perfectly understandable and useful and pragmatic phenomenon. But it is a bit of a shock to the system for other member states where culturally it just doesn't work. And I think the big challenge for organizations is going to be around finding their own corporate culture in relation to privacy, particularly if they operate across jurisdictions, and then making sure that that culture is compliant with the applicable legislation. And the culture that is set out by GDPR tends to have a very sort of Central European focus around it, and one which may not necessarily directly align with a particular business model or a particular type of organization. I think that's going to be a tremendous challenge, and that's where the accountability and the risk-based approach comes into play, which is about understanding what is it that you process, in what context and why, and how do you assess your compliance in an appropriate risk-based approach so that you feel it is defensible, that it is proportionate, and that it can withstand criticism on a go forward. Because the peers that are going to be judging you are not necessarily your peers within your sector, it is going to be the regulators. I think that's one of the tremendous challenges about the GDPR, is that when they give you accountability with one hand, they're also going to be judging you according to their rules on the other. And that's going to be a tremendous challenge. And interestingly, I was listening to the European Data Protection Supervisor last week, and the focus there was do not underestimate or be careful about flexibility. With one hand, we have flexibility, but do not think that that leads to a fall in severity. So flexibility and severity of enforcement, they felt that those were two sides of the coin, and that's actually quite an interesting dynamic, perhaps to keep in mind when we think about implementation and culture.
And I think one other element to this is that there's, in terms of the regulatory framework, is that there's going to be a move away from the sort of the engagement with the national authorities, because although the one-stop shop does allow for the main establishment of a international business to be based in to engage with the regulator within their where the headquarters are generally in the EU, the consistency mechanism in the European Data Protection Board actually provides opportunities for other regulators to intervene in cases, and effectively in the last resort those cases could be adjudicated by all the regulators in Europe. So there might be there's been a lot of talk about forum shopping, for example, around the sort of the international regulatory framework, but ultimately if there are concerned authorities, to the extent, for example, that data subjects are resident within that particular territory, then it could end up being a sort of multilateral decision which is made in all cases, which might reflect maybe sort of European sensitivities rather than, say, UK or Ireland or other places. So there could be a shift in regulatory perception and adjudication.
I agree.
Related to what you're both talking about, what I am picking up is first of all, the something Americans are quite comfortable with is the risk-based approach towards the GDPR. With that said, I'd be almost remiss if I didn't mention the tension that could be coming at us or arising between the EU's expanding regulatory approach with the GDPR, in that it shatters the traditional legal notion of borders and really has a extra jurisdictional approach towards its application. And so many U.S.-based companies will be swept up and under the GDPR need to comply. That in contrast with the new Trump administration's trend towards deregulation, there seems to be a real conflict between the two. Will this tension impact the cross-border movement of data? I know that's something that is critical to both economies, and I just worry that with the Trump administration having this attitude towards deregulation and the EU's prescriptive and expansive expansion of regulation, how do the two reconcile each other?
It's a big loaded question there.
Yeah.
But I think one of the interesting things to think about the GDPR is that it is a geographical piece of legislation grappling with an online world that knows no geography.
Right.
And therein lies the challenge. So the extraterritorial impact of the GDPR is reflective of the fact that it is trying to legislate in relation to phenomena on the internet, how things work in a globalized world, where you don't have to physically have a brick and mortar presence in order to operate in a particular jurisdiction. You know, that used to be the way in which you did things. Now you can set up a business on a website. You could be sitting on a beach in Tahiti and, you know, running your business from there and, you know, engaging with citizens in the EU. And the question is does that mean that you are covered or not covered by GDPR and other applicable legislation? And the decision there, of course, had been that yes, you will be. If you're offering goods and services or you're monitoring people in the EU, then yes, you must comply with the regulations. And that's the genesis of the extraterritoriality element to it. And you can see in that example, it makes an awful lot of sense. But of course, it has the ability to conflict, to impact, to rub up against in uncomfortable ways with other jurisdictions, other requirements. And of course, you know, as we said, this is not only a legislative piece, but it also demonstrates a cultural attitude toward privacy. And, you know, it's been an ongoing dialogue with its significant ups and downs over the recent years between the EU and the US about how they view privacy. The US has a sectoral approach. The FTC has been very clear about its enforcement powers, it's the rigor with which it seeks to enforce, but it's, you know, in the US it's sectoral, it's not horizontal. The EU is horizontal, and funnily enough, of course, up until GDPR didn't really have much of didn't have much teeth to enforce, as the case may be, but still felt they held the moral high ground in terms of the standard. So, you know, if I had my crystal ball, I would let you know which way it's going to go. I don't, but I think that there is absolutely going to be continued dialogue and tension in this area between the EU and other countries where their laws are evolving and reflect different cultural norms, different political circumstances, and how we navigate between that is going to be a huge challenge for global organizations. John?
Yes, and I think you know, the privacy shield is something which is still establishing itself. It's proven to be popular at the moment. Obviously, it replaced the old safe harbour, which the European courts determined didn't provide sufficient protection for EU individuals whose data were being transferred under this particular agreement. So, you know, I think what Privacy Shield needs to do is sort of bed down, and we can assess the success of it at some point. The European Commission will do an annual review, and the regulators will review its application as well.
Although the Libe Committee has already given their view.
Yes, they have. The European Parliament, you know, weren't particularly enthusiastic about it in the first place. But I think Privacy Shield was a practical, you know, response to dealing with some of the issues which are raised and concerns which are raised around safe harbour. But to some extent, you know, it's the need to preserve the ability for companies to register for a scheme like Privacy Shield and to be able to transfer the data between the US and the EU without necessarily going to a much larger expense of having a bespoke agreement in place, like a binding corporate rules. You know, the value of it is there, and I think governments on both sides of the Atlantic will hopefully recognise the importance of maintaining that free flow of data, as well as providing sufficient protections. But what Privacy Shield does do is it does actually recognise sort of European data protection principles to some extent, in that there are rights of redress for individuals and so on. So, you know, whether that's the expansion of the EU framework into the US, whether, you know, the US may, and the current administration may take umbrage with that at a particular point, remains to be seen. But, you know, I think to some extent it's still bedding down. It only started at the last year and still needs to sort of mature to some extent.
We have 5 minutes left and more questions than we can possibly get to, but here's one I think that you know, if we have to end on this one, I think it's a great place to end. Vivienne, let me start, get your thoughts on this one, but what's your take on the GDPR's impact for ad tech, the advertising technology industry? The onus to stay with first party, or is there a shared obligation between the publisher and the ad agencies?
You know what, the ePrivacy regulation is causing mayhem, and there's a lot of strong feeling about it because of the huge impact it's going to have for ad tech. And you know, when the ePrivacy directive was passed, it focused on cookies and similar technologies, but I think most people forgot the similar technologies and thought it only focused on cookies. And everyone agrees that the whole sort of cookie opt-in thing was a bit of a damp squib. So you know, it didn't achieve what it was set out to achieve, other than annoying notices popping up all the time that you click yes or no to, as the case may be. I think before we come to a conclusion about what the impact might be, I think that there's still a lot of lobbying to go in terms of the privacy regulation and the impact for ad tech. But I think it's important for ad tech to understand where the privacy legislators are coming from, and to see if they can perhaps help themselves through this discussion by demonstrating ways for greater transparency for users, so that they know what technology is tracking them and how it is being used. I mean, the reality is, you know, first-party cookies, even analytics, are often administered by third parties. So, you know, it's not that simple just to say, you know, first party, second party, third party. It doesn't really reflect the practical reality, and perhaps that's something that needs to be raised with the regulators. But I think it's too soon to say now what the impact will be, other than I think there's a lot of education that needs to take place, a lot of discussion still needs to happen, but I think the ad tech industry needs to start thinking innovatively about how they can meet those data protection principles around transparency and choice in order to move forward and continue in this area and avoid what might be catastrophic legislation for their business model, if I can be so blunt.
No, I think, thank you for being so blunt and candid. Both the ePrivacy reg and GDPR, I think, will affect ad tech as much or more than any other industry. And given the shortage of data protection expertise out there, you know, it is going to be a real challenge for the industry writ large to think of ways to be able to innovate and prosper while being under such scrutiny that both regulations are going to put upon the industry. So, but it's important because they are both the industry is an economic driver of millions and millions of jobs for both economies. Sorry, we've got a minute left, and John, I'd love to get your take on this question as well.
Well, I think you know, it'd be a shame if all these rules and regulations stifled creativity and innovation, because you know the digital economy has sort of revolutionized everyone's way of life over the last 20 years. So I think, you know, for first and third parties who are processing data, they need to sort of understand, is it personal data which they are processing, and if so, does it come under the scope of the GDPR, both in terms of material scope and territorial scope, and secondly, you know, what is the risk of harms to individuals? So, you know, the regulation provides for data protection impact assessments to be undertaken, and those risks should be carefully considered.
No doubt about it. Thank you for that. We are right against the top of the hour, so I want to be respectful of everyone's time, but Specifically, Vivienne, John, I want to thank you both very much for your time today and your insight. This was tremendous and a wonderful learning experience for me. So thank you both for participating. Got to wrap it up, but if any of our attendees would like a copy of the webinar or a link, or more importantly, a copy of the report, please feel free to reach out to me. My contact information is on this page. It is todd@evidon.com, and we'll be happy to provide that information to you. So thank you both, and thanks to everyone for tuning in, and have a great day.
Thank you. Also, for those of you going to the IAPP Global Privacy Summit next week in DC, Todd Ruback will be there in person. So if you'd like to meet him live, feel free to stop by at Evidon's booth number 25. Thank you, and have a wonderful evening.